All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Johnson versus Almeida, our cause number 1CA CV150416. Counsel, as I'm sure you're aware, we have read the briefs, conferenced the case before beginning oral argument today, so you can bear that in mind in your presentations. We are all being audio and video recorded today, so if you would announce your appearance and that of the party you represent when you approach the podium, we would appreciate it. Each side will have 20 minutes for oral argument. The appellant is free to reserve as much time as you wish for rebuttal, subject to watching your own clock. And with that, we can begin.
Thank you. Good morning. My name is Andrew Beck, and with my partner Bob Schmidt, we represent the plaintiff and appellant Barrett Johnson. I'd like to start, if I may, with this alleged conflict between Restatement Second of Torts Section 386 and the Gibson v. Casey case. The trial court here seized upon a phrase from Section 386 that stated, which he should recognize as involving an unreasonable risk of harm, and said that because there is a degree of foreseeability in Restatement 386, that it therefore conflicts with Gibson and 386 is no longer good law. And that's wrong for a number of reasons. For starters, a majority of the restatement sections concerning liability for landowners and lessees contain the same or similar language, and I can just give you some examples. Restatement Section 343, which has to do with landowners' duties to invitees, says, should realize it involves an unreasonable risk of harm to such invitees.
Does the restatement anywhere define the term duty?
It does, Your Honor, in the very beginning. Restatement section, I would believe it is 4 and 5, discusses what the court means, or what the restatement means when it uses the term subject to liability. And the subject to liability means duty and breach.
But that's not quite my question. Gibson makes much of defining duty very narrowly as a completely separate concept from liability. Does the restatement contain any similar definition?
I believe it does, Your Honor, but I do not have the exact quote off the top of my head.
Okay.
There are numerous other restatement sections that use this same language. 353, which has to do with land seller liabilities to buyers. 358, which has to do with the liability of lessees to lessors, where they, quote, should realize the risk involved. And those are just the ones that have been cited in our briefs. I went back and read through most of the second restatement yesterday, and there are more. 339, 342, 359, 364, 368, 370, 371, 379.
We'll take your word that there are many.
If 386 conflicts with Gibson, all of these restatement sections conflict with Gibson. And what that means is that landowners no longer have any duty to licensees or invitees. That's 342 and 343. Land possessors no longer owe any duty to anyone, whether on the land or otherwise, for dangerous conditions they create. That's 364 and 370. Landowners no longer owe any duty to trespassing children. That's 339. Landowners no longer have any duty to buyers or lessees, 353 and 358. If what the trial court concluded is correct, then Gibson v. Casey wiped out 2/3 of Arizona tort law having to do with liability of landowners. And that cannot be what the Gibson court intended. What Gibson intended is to restore the judge and the jury to their proper place in the courtroom. Gibson was an admonition to trial judges to stop looking at these fact-bound questions of foreseeability when doing your duty determination, and stop dismissing cases as a matter of law by finding that a certain harm was unforeseeable. Gibson is, in essence, expansion of the concept of duty. It means fewer cases should be dismissed, not more, because the trial court judge should not be looking at whether this particular harm was foreseeable. But the fact that a restatement section mentions foreseeability does not mean that it is overruled by Gibson v. Casey. Now, 386 has never been adopted by Arizona courts. We concede that. It's also never been rejected by Arizona courts. And the reason for that is that it describes kind of an unusual situation. It's a situation where the tortfeasor is not a landowner. They're not acting on the landowner's behalf. They create an artificial condition on someone else's land that it's foreseeable, it's unreasonably dangerous, and it causes injury to someone. Now, the fact that Arizona has never formally adopted 386, we look to what does Arizona do when we don't have a restatement section that's been formally adopted. And under Espinoza v. Schulenberg, unless there is conflicting authority, Arizona courts generally follow the restatement. And that's been the case in every single state that has addressed 386. Oregon, Iowa, Minnesota, Maryland, Mississippi, Pennsylvania, Connecticut have all adopted 386. And after searching, I was unable to find a single state that has not or that has rejected 386. If Arizona rejects 386, it would stand alone in this country as courts having done that. 386 doesn't use the word duty. It talks of being subject to liability. Subject to liability is defined in Restatements 4 and 5 as duty plus breach. So when the restatement talks about being subject to liability, it's talking about both of those. And when you have duty plus breach combined with causation and damages, subject to liability becomes liability. Now, we've illustrated in the briefing the way that 386 can be sort of carved up into its component parts, where it's talking about duty here, it's talking about breach here, causation here, damages here. But I don't think you necessarily need to do that, because it really, what 386 is talking about is what all of these other restatement sections talk about, is the whole panoply of all four elements of tort. Now, if for whatever reason the court decides that 386 shouldn't apply in Arizona, you can still adopt a duty based on public policy. And what Gibson says is that the existence of a statute criminalizing conduct is one way that we can find a public policy argument for duty under Arizona law.
Do we need to adopt a duty as a matter of policy? Let's say that the 386 doesn't apply. Wouldn't any holding to the effect that there is no duty be tantamount to landowner immunity? And so that, it would seem to me, would require an affirmative holding as a matter of policy.
I agree, Judge Swan.
But the contrary holding doesn't seem to involve the creation of anything new.
I would agree, other than the fact that this exact situation, as envisioned by 386, has not been considered by Arizona appellate courts before. But as a matter of public policy, it makes perfect sense.
But under Gibson, I wonder whether one really needs to find a duty in every conceivable, bizarre, factual scenario. Isn't the more pressing question under Gibson whether there is a fact situation in which no duty exists? Because that's the rarer circumstance.
I would agree that the court alluded to that, and that's really the Restatement 3rd, Section 7A view of duty.
Well, that takes my question all the way to the far end of the spectrum, which the court declined to do, of course. But it left us, I think, with the impression that unless there is to be immunity for a certain category of cases, then there is a duty. That doesn't tell us a duty to what, right?
Correct.
The content of the duty may be minimal or almost non-existent, but if as long as there can be liability under some facts, then that would seem to imply to me under Gibson that there is a duty. It's just that duty doesn't get you very far.
I would agree with that, Judge Swan. And I think the scope of the duty, what the duty requires Almeida to do, is really a breach question. The duty, while a lack of a duty, as Gibson stated, is a finding that no matter how reckless or careless you are, you cannot be liable. It is, in effect, immunity.
So the presence of a duty is simply the absence of immunity and nothing more.
I would agree with that.
Would that be fair to say? Okay.
But what is the effect, if any, on the question of ownership of the structure?
I think that only comes into it, and as you'll see from the briefing, we've argued in the alternative, if the court doesn't accept 386, that 383, 384, 385 could apply conceivably. And that, I believe, ties in the ownership and puts Almeida in the position of a landowner if they were acting on behalf of the Forest Service.
And what about this question about whether you were, the owner of the fence was acting to benefit the Forest Service or not?
Your Honor, I think that's the 386 versus 383 through 385 question. If Almeida is not acting on behalf of the Forest Service, it's 386. If they are, it's 383 through 385. They are mutually exclusive.
And does 383 through 385 really get you anything that 386 doesn't?
I believe it's a different framework for liability, because what 383 through 385 does is simply place Almeida in the same position as the landowner, whereas 386 does not use that same language. It's more of a liability for creating the structure as opposed to placing you in the shoes of the landowner or lessor.
Understood.
And so, as I understand your brief, you're arguing that the foreseeability in 386 is a breach question,
Correct.
not a duty question.
Correct.
Okay.
All we're asking, we're not suggesting that foreseeability does not still need to be determined in this case. It simply needs to be determined by the jury because it is a fact-bound question. Your Honor, to your point about immunity, I think Judge Mackey reached the same conclusion that you did, in that he was troubled by his ruling. And what he said in his ruling was, the court is hopeful that further appellate proceedings will serve to clarify this complicated issue of duty when, as suggested by the plaintiff, the finding of no duty incentivizes the defendant to do nothing, and the risk of injury to others who use the Prescott National Forest for recreation will continue. I would suggest that's an invitation from Judge Mackey to reverse him, because he was troubled by the public policy implications of no duty here, and therefore no incentive for Almeida to do anything. And 2 people have already been seriously injured by these fences on the Prescott National Forest, and they have no incentive to do anything else if they are immune.
Reversal is one party we usually don't wait for an invitation for.
I'm sorry?
Reversal is one party we usually don't wait for an invitation to.
I completely understand. Your Honor, Almeida has also argued that finding a duty here would mean that their duty is somehow unlimited, that it's a duty owed to anyone and everyone, and that conflicts with some of the language in Wertheim and Bloxham about it is not our understanding that the law is that everyone knows a duty to everyone at all times. But it's really more circumscribed than that. When Bob and I got in the car and drove down here this morning, in some senses, Bob, who was driving, owed a duty to everyone on the road, all the passengers in his vehicle, the pedestrians on the side of the road. But in reality, it's more circumscribed than that.
Well, he didn't owe a duty to surrounding landowners to protect them from cancer that might result from inhaling his exhaust fumes.
Correct. But I would say that what you're talking about is a breach question as opposed to a duty question.
Why? With regard to the cancer?
Yes,
and the exhaust
because
fumes?
we're talking about the foreseeability of that very strange.
Well, I think there are some who would argue it's very foreseeability that automotive emissions are unhealthy and will someday cause harm to some people.
I would agree.
But I think it's pretty clear that drivers on the road are not going to be held liable in tort merely for the act of burning gasoline in their cars.
Correct.
And that to me would seem to be a question of duty.
I think you can say that you have a duty to an undefined class of people, which may or may not include the people who are on the land and inhale his gas fumes. But you have to look at the other 3 elements of tort as well. Is that foreseeable? Did he do something unreasonable in operating his motor vehicle. Did that emission actually cause the harm?
Well, I guess the reason I characterize it as duty is if a ardent lawyer were to come in and say, yes, he did do something unreasonable by getting in a car and starting the engine. He did something unreasonable because we all know that that stuff could hurt us. I think that case would be subject to a motion to dismiss because there's a lack of duty. It would not be a fact question whether it's unreasonable to get in a car.
I think you could make that argument. Duties are not unlimited, but in the same sense, Almeida's duty is not unlimited either. They owe a duty to those who may be injured by their cattle fences that they place on the Prescott National Forest. It's not a duty owed to the world or the universe. It's circumscribed by the circumstances. So in some senses it's fact-bound, but in other senses it's just, it's just a duty question as you articulated it. Your Honor, if I may, I'd like to...
I wonder, with all this discussion for better part of a century about the definition of duty, whether duty is a terribly useful concept or term, but you don't have to answer that.
Well, I'd be happy to if you'd like. I think Gibson v. Casey recognized that as well, that it is a hopelessly muddled area of law that, at least my personal feeling on it, is that it is going to move towards the restatement 3rd, Section 7A concept of duty because it makes it much more simple and clear-cut than trying to look for relationships between people or look for duties undertaken gratuitously or what have you, when you could just step back to what the court said in Ontiveros v. Borak. Everyone's under a duty to avoid injuring other people by acting unreasonably. Your Honor, if I may, I'd like to reserve the balance of my time for rebuttal.
Of course.
Thank you.
Good morning. May it please the Court. My name is Matt Clyfield. I represent the appellee in this case, Almeida Land and Cattle Company. From the outset, I guess I should tell the Court that I strongly disagree with the suggestion that appellant made to you that the Gibson Court stood for the idea that they're just trying to define what the trial court should do in defining duty and what the jury should do in deciding factual questions. In fact, I don't think the court did that. And Gibson stated, to clarify, we now expressly hold that foreseeability is not a factor to be considered by courts when making determinations of duty, and we reject any contrary suggestion in prior opinions.
So in your view, is it correct that Gibson was intended to be this sort of charter of immunities and a massive rollback of tort liability in Arizona?
I don't agree it's a charter of immunities. I do agree it's a sea change of the Arizona Supreme Court's view on duty in terms of many decisions that came before Gibson and what some of the courts of appeal or Supreme Courts in those decisions did in trying to assess whether a duty existed or not in taking a look at facts.
Okay, well, let's start with definitions then,
Yeah.
because we always get caught up in these things with duty. Would you agree that the absence of a duty is equivalent to immunity?
No.
Okay, why not?
I think immunity recognizes some type of duty, but there is exception or protection from any liability arising from it.
All right, fair enough. Immunity is more of a defense than the absence of an element, but the net effect is the same, isn't it? If there is no duty, then there is no liability no matter what the conduct.
If there is no duty, there is no obligation to protect another from harm that is claimed. No duty in one circumstance doesn't suggest there might not be duty in another. No duty from one individual to another might not suggest there is no duty owed from that same individual to a second or different person in a different circumstance.
But your position here is that your client owed no duty to anyone.
Our position here is our client owed no duty pursuant to either a special relationship or a public policy interest to a similarly situated individual as Mr. Johnson.
Okay. So then if your client erects a fence for grazing purposes, right? And let's say your client is concerned about predatory animals harming its cattle. So it decides to dig a moat around the fence and cover that moat skillfully with some sort of thatch-like substance so nobody can see it. And just to make sure those predators don't find the cattle, it puts up no signs. Does it owe a duty, or can it just do that and trap people routinely walking through the forest without any liability at all?
I think what we would look to in that circumstance is we would look to the permit that was issued. We would look to what the federal government has permitted pursuant to this being its lands.
I don't know that we need a Forest Service to define state tort law for us. What does Arizona law say about somebody who creates a knowing hidden hazard for the purpose of catching certain mammals and maybe not intentionally catching others?
Well, I would suggest that what Arizona state law stands for in light of Gibson is, number one, was there a special relationship that existed between the person that built that moat and the person who's subsequently injured by it? If not, is there a public policy consideration that can be found to support the idea that that would establish a duty?
Okay, so in my hypo, what's your answer?
I don't know. I'd have to take a closer look at it.
I think it might be possible that Arizona tort law would support the notion that this moat digger would simply face no liability to anyone.
It might be possible. I think there are circumstances where we can look at a harm, an act, an event that has occurred, and feel rather astonished that it occurred and that some particular individual is not responsible for that. That doesn't mean that the individual that's injured doesn't have the right of recourse against someone else. For example, the Forest Service for permitting that type of activity upon its property, which, frankly, I would submit is the proper recourse here. That's who should be looked to for consideration of whether there was a duty owed to Mr. Johnson and ultimately whether liability attaches to that duty. The idea that one individual may not be responsible because of lack of duty does not suggest the injured individual has no recovery or no recourse.
So because duty and the content of a duty are separate things, we can agree on that, right?
I think if you mean by content scope, I don't know that they really are a different thing, because you've got to identify duty in light of what the scope is. You may have a general duty to do something, but that has an end and a beginning. That's its scope.
So, but then under your view, it is possible then that Alameda could be immune from any conduct it does to protect its cattle because of the contents of a Forest Service permit. So if it puts people out in the Forest Service simply firing random shots every few minutes into the forest to ward off predatory animals, and some of those bullets catch humans, no liability.
I disagree. I think in that scenario, you could certainly look to public policy considerations. In fact, I believe that's a prohibited activity pursuant to the United States Forest Service regulations. And the public policy derived from those regulations would support the idea that that individual shooting a firearm in a United States forest does not have the right to do that, and or a duty attaches to his not injuring individual from that conduct.
But it's legal to do so on state land. So if this were a state land grazing permit, that would be okay?
I think there are limitations on what you can do on state land. I think, and I can't tell you that I know it verbatim, but I believe there are rights to fire a firearm on state land, but that's limited. You can't do it within, I think it's a certain mileage of homes or occupied structures. In that scenario?
Because you might hurt someone.
Because you might hurt someone, but that allows us to have the public policy foundation to define duty. If you're not,
and that brings us full circle. I mean, that's the interesting discussion, and why I asked whether duty is even a useful concept. Because what we have just talked about, somewhat intentionally, was the notion that foreseeable harm tends to follow duty, and yet Gibson created this sharp divide between duty and foreseeability. So, does it make sense to have the discussion we just had and say that duties exist when the conduct becomes palpably dangerous, but not otherwise? It seems to me that that's what Gibson displaces and not the restatement.
I believe the discussion we had regarding firing a firearm on state land within certain distance of an occupied structure and the idea that duty can attach to that conduct arises from public policy defined likely by statute or regulation. I believe that the legislature would have created those perhaps because they recognize the potential for harm. The duty is not created because the person firing the gun recognizes the potential for harm. The duty is created because of the public policy which has its foundation in that statute and that regulation. So the person who's firing the firearm may say, I didn't even know there was a house over there. I couldn't foresee there being any harm. Doesn't matter. Foreseeability is not in the mix. There's a duty anyways because of the public policy.
Go ahead. Go ahead. What you're saying is, then, absent a permit or regulation or a statute, your client could do anything it wanted. If it was on state land and there wasn't a regulation that said you can't fire firearms. Let me come up with another example.
Sure.
You have grazing land, and there's no permit requirement, there's no regulations. So you put a fence to keep the cattle in, but you're worried about predators. So you put an electrified fence on the outside of that fence, and you charge it to kill predators with enough electricity that any wolf or other predator that's going to come through is going to get killed and electrocuted, and you don't have any warning signs. And a person's hiking through the forest, sees the fence, thinks it's just a fence, touches it, and is killed. No duty. Right?
I would suggest, certainly in terms of the special relationship between the two, no duty. I would have to explore whether or not there's a basis in public policy to support the idea of that duty.
Or should you be exploring the question whether there's a basis in public policy for the absence of a duty? Isn't that the more relevant question? What public policy supports the notion that your client enjoys some special freedom to injure people with high voltage fences or covered trenches or anything else that an ordinary contractor would not enjoy?
Well, I think in the evaluation of whether there's a public policy that would create duty, that's part of the calculus, determining what public policy stands for in that respect. For example,
I'm at a loss to find a public policy that says your client should be treated differently than everyone else.
And I'm not suggesting it should be treated differently from everyone else. There, I believe, are cases that have been cited for the court's consideration that deal with the concept that there are circumstances where there is no duty. And you might argue that means immunity. Sabina really didn't deal with that. They found there was duty, but ultimately the proximate cause did not cross with the duty. But I believe there are other cases that we cited in that respect. Certainly, I think there's several of them. But it doesn't mean immunity. It means in that circumstance there's simply no duty. I think that you have to take a look at public policy on both sides of the ledger, though. For example, if we were to take a look at the public policy that attaches to my client's conduct in this circumstance, building a fence to segregate pasturages, to maintain the quality of the environment, to protect the cattle, to keep them from roaming otherwise on United States Forest Service property. There is a social benefit in doing that. There's a public policy benefit in doing that.
Is there a social policy or public benefit in not putting a sign or putting a warning sign?
Well, I believe the Forest Service would suggest as much, and the record bears that out. They wanted these fences to blend in. They want these fences to not mar the natural landscape. They don't want an orange fence with a whole bunch of ribbons on it. They are trying, as the federal government, to balance its needs and interests.
There's a social benefit to having underground sewers and manholes covering them, but we don't say that there's no duty to make sure the manhole is in place just because the sewer provides a benefit. I guess I'm a little nervous with the idea that Gibson created a license for courts to micromanage people's conduct by articulating policy they find nowhere but in their own minds. That seems to me to be a slippery slope to a role for courts that you may not want.
Well, I think that's the converse of what Gibson does. I think Gibson's expressly telling the courts not to do that, not to micromanage, not to explore these little details of every case in an effort to define whether or not there's duty. Eliminating for foreseeability so you don't have to do that. Is there a need to understand some facts of a case in order to define whether there is a duty? Sure. Are you a landowner or an invitee? Are you an innkeeper or a guest? You have to have an understanding of the parameter, but beyond that, I think Gibson stands for the proposition that no, trial judges, we don't want you doing that.
We want juries doing that. That's
We-
what Gibson says.
What Gibson says is we don't want foreseeability as an element of defining duty, which is exactly what Judge Mackey said when he rendered his decision on the motion for summary judgment.
But of course, Section 386 doesn't say that foreseeability is a part of duty. It says it's a part of liability.
Ultimately, if you read 386 from my perspective, the language that Judge Mackey quoted says exactly what Gibson suggests you shouldn't do. It speaks to foreseeability.
The section does not contain the word duty, as I recall.
I think that the restatement in of itself, the sections are addressing the concept of duty in and of them in order to create liability.
Well, you might argue that. You might also argue that where the restatement prescribes liability, it has already assumed a duty, and what is really getting to is the content of a duty in various factual situations. Because I think it's quite a stretch textually to say that the restatement must be talking about duty when it is a simple four-letter word that doesn't appear in the restatement.
Well,
and yet the word liability clearly does appear in the restatement.
It does, but liability as a basic premise, and I think it's even set forth in the Gibson Court's decision as well as decisions thereafter, as I recall, deals with four concepts as an element, as the requisites of liability, one of which is duty. You can't have liability without duty.
Right. So any place that the restatement prescribes liability, we may assume that the restatement believes there's a duty, otherwise there would be no section.
But the restatement is addressing whether a duty exists in those circumstances in an effort to allow you to reach the conclusion of liability.
I can well understand how colloquially we might make that argument, but where in the text of the restatement do you find support for the precise distinction between duty and liability that you just made?
Well, I think you have to take a look at the particular restatement sections, and I think 386 in fact does that.
Again, 386 doesn't use the word duty, so where do we draw the distinction between duty and liability in 386?
Well, I believe ultimately you do that by a plain reading of the language of 386, as I submit Judge Mackey properly did. I believe where you recognize the term which he should recognize as involving an unreasonable risk of physical harm is a necessary definer of what the duty is.
But under Gibson, why don't we simply say, jury, you figure out whether that was foreseeable?
Because Gibson says we've got to address the concept of duty in the initial instance. Now, and Gibson says foreseeability has nothing to do with duty any longer. We've got to define whether a duty exists in the initial instance. Absolutely have to. And there are clearly circumstances where it doesn't. That's what the court is tasked with. And it's now tasked with doing it without trying to consider whether it was a foreseeable risk, a lot of which we've discussed here today. We've talked about foreseeability here today. We've talked about whether it's foreseeable that somebody who digs a ditch on Forest Service land might create a trap for somebody to fall into. That's not the proper province of duty. We don't consider that any longer in duty pursuant to what the Arizona Supreme Court says.
Does that mean there's no duty? Just because we don't consider it as part of duty? Does that mean perhaps we consider it as part of something else, like breach or cause, and not as part of duty, meaning that the restatement doesn't tell us when there's no duty?
I believe that Arizona law, case authority, and statutes, when read in conjunction with the restatement, does tell us when there's duty, and does tell us how to get to the conclusion of whether a duty does or does not exist. And it's not always going to be defined by the restatement. The restatement does not always guide us where there's a conflict in Arizona court decisions or statutes, and I submit there's one here between Gibson and 386. The restatement second, created in 1965, particularly in light of the Gibson decision, is not the end-all of our consideration on that issue.
To be sure, it's not the end-all, but not everything that was created in 1965 is obsolete.
I agree,
The Court
especially
of Appeals
me.
itself was created in 1965.
Yeah.
But getting back to the text, are you aware of any place in the restatement where the restatement second actually says there is a duty? Because I'm not.
I'm not either, but it recognizes in the restatement that duty is a concept that is implicit in what it's discussing. It defines duty.
But it does not define, through all of its hundreds of sections, it never says, in this circumstance, someone owes a duty. What it says is, in these circumstances, someone may be liable.
And implicit in that is the suggestion of duty.
Absolutely. You can't have liability without duty.
Mm-hmm.
But does that then mean that all of the facts necessary to support liability are also necessary to support duty? Because it doesn't say that.
No, I'm not suggesting that's the case. All the facts necessary to support liability may deal with issues dealing with breach and causation, and that's a different consideration. Ultimately, the very first consideration, as we've discussed in our papers, is, was there a duty? And ultimately, the plaintiff has the burden of demonstrating that there was a duty, either through the existence of a special relationship or public policy, neither of which have existed here. And they've tried to create that by pulling in restatement sections, which I believe the court has properly rejected because, in the case of 386 in particular, it's in conflict with Gibson, because I submit it does include foreseeability considerations which are not properly considered in evaluating duty. All right, thank you.
Thank you very much.
Judge Swan, you pointed out an important point here, that a lack of duty is, for all intents and purposes, immunity. And Gibson really says that. Gibson says a conclusion that no duty exists is equivalent to a rule that for certain categories of cases, defendants cannot be held accountable for the damages they carelessly cause, no matter how unreasonable their conduct. A finding of no duty is a license to do whatever you want, everything short of an intentional tort. And I mean, I don't see how that is any different from the concept of immunity.
Counselor, can I ask you a question about Section 385?
Sure.
Now, this case was resolved on summary judgment, as I understand.
Correct.
And was the summary judgment only about duty?
Yes, Your Honor.
So under Section 385, there's this question of the acceptance of the work by the Forest Service, correct?
Correct.
So I take it you've not been required yet to set forth a factual basis for your assertion that 385 creates liability. Is that fair to say? I'm just curious of what
Sure, Your Honor.
I'm curious of what your theory is about how the Forest Service would have accepted this work. And apparently you've not been challenged on that yet. Is that fair to say?
I think that's fair to say. I think it's fair to say that if you look at what Judge Mackey ruled, he never got to that question. His problem...
Summary judgment papers get to that?
Yes, Your Honor. I mean, the summary judgment papers, I think, are pretty broad, and I think there's a lot of disputed issues of material fact about who owns the fence.
So Alameda did challenge whether you had evidence sufficient to go to a jury on the question of the Forest Service accepting this work?
Yes, I believe so. The motion for summary judgment was quite broad, and by the time we got to oral argument, I think we really boiled it down to the essence, which was 386, and if not 386, then 383 through 385.
But what is your factual scenario for how the Forest Service might have accepted this fence?
Well, there is a federal regulation out there that
I
says...
assume if we let you, you're going to go back and want to prove this, right?
Well, sure. Again, 386 and 383 through 385 are mutually exclusive.
Correct.
If there is a duty under 386, we don't have to get into any of those questions about 383 through 385, about accepted work, about any of that stuff. And we would submit, and I believe that the defendant would actually agree, that 386 is the appropriate section, although they do not agree that it is applicable.
So if you win on 386, you don't see any need to address 383 through 385?
I believe that's exactly correct, because they are mutually exclusive. And if you look at what Judge Mackey did below, he took the time to go through all these sections and find what the problems were, but it was really based on 386, and that's what he started with. And if you look at the transcript of the oral argument on that, I told the judge point blank, I think 386 is the right one. I don't think you need to get to any of these other sections.
So if we were to reverse and say there was a duty under 386, you would argue, your position would be there's no need for us to address 383, 384, 385.
I agree.
That would just basically be moot.
I agree. There's no need to go there. We argue in the alternative simply because either way,
Sure.
there's a duty.
If we agree, your arguing the alternative is because if we said there was no duty under 386, you'd want us to see if there was a duty under 383, 384, or 385.
That's correct,
But
Judge
your
Kessler.
argument is that if there's no duty, if there is a duty, if we held that there is a duty under 386, then we don't need to address the other sections.
You don't need to address anything else from our perspective, the public policy, 383 through 385, any of the other things. And I see my time is up. Thank you very much.
All right, thank you, counsel, for your arguments. This matter is now under advisement. We will issue a written decision in due course, and we stand adjourned.